Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-immigration. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And while I recently had the opportunity to talk to the folks at Serenade about their case management system, e-immigration, they've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Recording this week on March 15th. Beware the Ides of March. Beware, I say. News of note. And really, there's so much immigration news to always choose from these days. So I choose to note that on Friday, March 14th, our law firm, in tandem with Just Futures Law and the law firm Bryan Cave Leighton Paisner LLP, filed suit in the Eastern District of New York to challenge the Trump administration's rescission of TPS for Haiti. Something we are correctly calling the administration's unlawful premature termination of TPS for Haiti. This is largely the same attorney team that sued last time in the Eastern District of New York when the Trump administration unlawfully terminated TPS for Haiti the first time. Last time, we stopped it. Let's see what happens this time. Huge props to Bryan Cave and their hardworking attorneys who put in the most hours getting these and forthcoming papers drafted, and honestly, for remaining committed to this work, even after the Trump administration's blatantly unlawful targeting of Perkins Coie for similarly working on things that the Trump administration doesn't like. The immigration community appreciates you, Bryan Cave. Ira and our law firm continue Ira's over 4-decade fight for the Haitian community. And I'd be remiss not to also mention Steve Forrester, an attorney and community advocate who's been fighting this fight with Ira pretty much the whole time and who put in lots of hours with me to secure plaintiffs. The fight commences, again, and never really stopped, thanks to advocates like Ira and Steve. Our case is Haitian Evangelical Clergy Association et al. v. Trump et al., which we'll also be calling HECA for short. Heck of a lawsuit, if you ask me. I believe I am contractually obligated to only use that pun once, and I took it. Our suit is in the Second Circuit, and it now joins similar suits in the Ninth and First Circuits. And while we're on the Second Circuit, that court amended its very important mental health type decision, Reed v. Garland, originally discussed on episode 237. Still a remand, and still important. 6 cases this week. And I read the final one late Friday night due to a very fun Ayla San Diego karaoke event. The decision last night of a 2-member couple to close the night singing Killing in the Name of by Rage Against the Machine, with a whole chapter chanting along, really is indicative of where the immigration bar finds itself these days. Some of those that work forces. You know the rest. Case time. Our first case is Rosa v. Bondi, published by the First Circuit on March 14th, 2025. This case is about termination of removal proceedings. Mr. Rosa and his wife entered the United States without authorization near Texas and were charged as removable for that reason. The notices to appear allege that they were from Brazil. Mr. Rosa and/or his attorney must have not admitted and conceded, though, to the allegations in the NTA and the charge of removability, because the immigration judge ordered DHS to submit evidence of Mr. Rosa and his wife's alienage, the first allegation in an NTA. Even though a Section 212 IWI charge was brought, meaning that the non-citizens have the burden to establish their admissibility, DHS always has the initial burden to establish alienage. That is, that the non-citizens are not U.S. citizens. In support of their IJ-ordered burden, DHS proffered a, quote, EARM summary, end quote, for each respondent. Quote, ERM is an acronym standing for the Enforce Alien Removal Module, describing a software that is part of DHS's Enforcement Integrated Database. That database, in turn, is a repository of information for use in law enforcement and homeland security applications, end quote. So submitting that report in immigration court is like multiple levels of hearsay. The ERM had biographical information and alleged Brazilian citizenship, and it contained an I-213 within it seems. Standard DHS alienage filing, to be honest with you. But Mr. Rosa challenged the liability of these ERM summaries, alleging, for example, that they were flawed because they lacked the names of the CBP and DHS agents involved, omitted information about Mr. Rosa and his wife's parents and their nationality, and that the I-213 within it contained generic language that was clearly inapplicable to Mr. Rosa and his wife. Also, apparently, Mr. Rosa's ERM summary referred to him with feminine pronouns. Quote, there was more. End quote. While the ERM alleged the petitioners were fluent in Portuguese, it said the warnings to them were given in Spanish. End quote. The narratives within the ERM summaries were dated a week after the date of the alleged encounter with CBP. End quote. Not gonna lie, none of this is wild stuff to me based on ERM summaries and I-213s that I've seen in the past. Making the fact that the First Circuit granted this petition for review possibly so important, even though the petitioners in this case have never denied being from Brazil. First Circuit doesn't believe the ERM summaries, even with the I-213s apparently included, necessarily meet DHS's burden here. That's a statutory burden at INA Section 101A3. The holding is more nuanced than that, though, of course, it always is. The IJ held that the ERM summaries met DHS's burden to establish alienage by, quote, clear and convincing evidence, end quote. But in the seminal Supreme Court decision, Woodby v. INS from 1966, the Supreme Court held that the degree of proof required for establishing alienage and lots of things under immigration law is, quote, clear, unequivocal, and convincing evidence, end quote. Mr. Rosa made this standard argument before the BIA, that the IJ applied the incorrect standard, but the BIA rejected it, saying that those two standards are the same thing. But they're not. Explain the First Circuit. And before you roll your eyes, the Sixth Circuit is about to rely on a similar innocuous textual difference in a different statute to rule against a non-citizen in a big way later this episode. Anyway, it's true that the INA has supplanted the Woodby standard in some circumstances, requiring only a clear and convincing evidentiary showing on removability, for example. But the IRIRA amendments, perhaps intentionally and perhaps not, are silent as to what DHS's burden is on alienage. Meaning to the court, Woodby remains. And that means it's clear, unequivocal, and convincing evidence. Not just clear and convincing evidence. And that means something heightened. Unequivocal is quite the word, after all. Heck, the Supreme Court said this exact same thing in Att'y v. Texas, albeit in a different context, but comparing the same phrases. From that Supreme Court decision, quote, the term unequivocal taken by itself means proof that admits of no doubt, a burden approximating, if not exceeding, that used in criminal cases, end quote. That's a pretty high burden. By the way, I'm pretty sure, but not 100%, that this same definition applies to INA Section 101A13C's framework that permits DHS to treat a returning lawful permanent resident as an applicant for admission. I believe that is also governed by the clear, unequivocal, and convincing evidence standard. That phrase is also expressly used, for example, to describe DHS's burden to prove, quote, that written notice of removal hearing was provided for in absentia orders, end quote. Just saying, that phrase is found and applied throughout the INA. So that makes this a pretty important case, given what the First Circuit is saying the word unequivocal means. The First Circuit's holding aligns with the decision out of the Sixth Circuit, Ward v. Holder, but it conflicts with a split Ninth Circuit decision, Daca Vega v. Lynch. Come on, Ninth Circuit. Will Mr. Rosa and his wife ultimately succeed? To be determined. But the BIA and presumably the IJ need to now go back and see if DHS has met its heightened standard. Meaning, congratulations, Annalise M.J. De Rojo and Stephanie Fisher-Pinkert for petitioner. And that is Rosa v. Bondi. Next up is Wilkinson v. Attorney General of the United States, published by the Third Circuit on March 11th, 2025. This case is about hardship and non-LPR cancellation of removal. Mr. Wilkinson is from Trinidad and Tobago. And yes, indeed, it is that Mr. Wilkinson, the Mr. Wilkinson who won before the Supreme Court last term. The Third Circuit had previously held that it lacked jurisdiction to review this issue at all, but as we know, the Supreme Court said otherwise and remanded. That is, whether circuits can review a finding by the IJ and the BIA that a non-citizen did not establish that his qualifying relative will suffer extreme and exceptionally unusual hardship for non-LPR cancellation of removal. Having been remanded, the Third Circuit has now reviewed that issue, and it dismissed this petition. As the court explains, Mr. Wilkinson fled Trinidad in 2003 in fear for his safety. He entered the United States on a tourist visa, overstayed due to a weird criminal type thing, and has remained. He has a U.S. citizen child. He pays child support for the U.S. citizen child and is involved in the child's life. He came in contact with ICE after law enforcement arrested him under suspicion of drug possession. While that case was dropped, ICE got wind of it all and initiated removal proceedings. About a month after Mr. Wilkinson's arrest and detention, his U.S. citizen child began acting out, breaking things, and just generally being sad. The evidence shows that all of this was likely a result of Mr. Wilkinson's detention and the child's fear for his father's removal. It also appears that the child's mother testified at the removal hearing. The child would remain in the United States, she said. And she also, quote, expressed concern that her son does not have other male role models and that he needs his father. In addition, the family would suffer financially. The mother would need to find a job as well as childcare and would no longer be able to rely on Mr. Wilkinson as a second caregiver, end quote. As mentioned, the immigration judge denied on hardship and the BIA affirmed. The hardship to the child, known as M in these proceedings, was not extreme and exceptionally unusual, as Congress has seen fit to mandate. The Third Circuit has now reviewed the issue and affirmed. First, the Third Circuit believes that the Supreme Court was unclear in its Wilkinson decision on what standard of review the circuit should apply. A bit of a circuit split has developed on that issue, or at least a few circuits have kind of avoided it while applying a non-specific deferential standard of review. To the Third Circuit, the standard of review, though, is whether the BIA's findings are supported by substantial evidence, a fairly deferential standard used in many other immigration situations. It is kind of weird, though, right? Because the whole reason that the hardship question is reviewable at all, post-Patel, explained the Supreme Court in Wilkinson, was because it's a mixed question of law and fact, which is usually treated like a question of law for review purposes, which means de novo review. Because the Supreme Court also said that this mixed question is, quote, primarily factual, end quote, and that the review afforded is deferential. So it's like the Supreme Court kind of created a subcategory of mixed questions of law and fact? I don't know. I don't want to get too deep into it, but in addition to what I just mentioned, the Third Circuit picked substantial evidence review because after going through quite a bit of cases and discussions, It reasoned that trial courts are the fact finders, and it just makes sense. In deferential review territory, the Third Circuit affirmed the agency's no hardship finding. The non-LPR cancellation of removal hardship standard is high. Quote, while this does not mean that the consequences of deportation must be unconscionable, it does limit relief to truly exceptional situations. This makes sense, end quote. Regular family separation hardship? A-OK under U.S. immigration law. That high standard was unmet here, although M. quote has eczema as well as asthma, a serious medical condition, end quote, and was definitely affected by Mr. Wilkinson's detention psychologically. M hasn't lived with Mr. Wilkinson for years, showing that they can live separately. These are part of the IJ's reasons, and the Third Circuit believed it all logical. Plus, Mr. Wilkinson can still send money back if he gets a job in Trinidad. The Third Circuit is, quote, sympathetic to the plight of Mr. Wilkinson and M, as well as the hardship that Mr. Wilkinson's removal will cause M, end quote. But this is what Congress wanted in 1996, apparently, expressing the will of the American people. And so, it is what it is. The court seems to be saying, quote, struggling, feeling sad, and acting up are exactly the responses we would expect when a beloved parent faces deportation, end quote. Importantly, and unlike other cases where relief has been granted, there was no testimony, quote, of a mental health provider or diagnosis of a mental health condition to establish both the severity of the condition and its nexus to the parent's removal, end quote. Bring your experts to court, y'all. The Third Circuit is telling you to do it, not me. That M's mother appears not to have wanted such a psychological analysis, and so prevented its occurrence, doesn't change the fact, explains the court. Nor the court explains will M lose his health insurance without Mr. Wilkinson. Even though M's mother apparently does not work, the Third Circuit believes she can. Rejecting some other arguments, noting that the IJ correctly aggregated all sources of hardship, and not thinking the IJ and BIA out of bounds, the court affirmed the agency. And that is Wilkinson, the Attorney General of the U.S., post-remand. Moving on to two from the Sixth Circuit. First being Rahman v. Bondi, published by the Sixth Circuit on March 13th, 2025. This case is about extreme hardship. Not exceptional and extremely unusual hardship like the Third Circuit case I just did. But reading the summary of this decision, it did make my eyes go wide. Extremely so. Miss Rahman is from Bangladesh and has 5 U.S. citizen children. Her husband is also a U.S. citizen and they've lived in Ohio for over 30 years, it appears. This case is about to get complicated. It seems like they've been married for a while, but the religious versus civil marriage thing can sometimes be complicated in the Muslim cases. We know for a fact that they received an Ohio marriage license in 2017, but again, they had been together for a very long time and held themselves out as religiously married for a long time before that. Miss Rahman initially obtained an H-4 visa way back in 1992, connected to her husband, but she overstayed. Then she left and she was forced to live in Bangladesh from 1998 to 2000 because CBP wouldn't let her back in. And here we go. Quote, during this time, U.S. immigration authorities took 2 contradictory actions regarding Ms. Rahman's immigration status. After one of her attempts to re-enter the U.S., the authorities placed her in removal proceedings. She did not attend her hearing and an immigration judge ordered her removed in absentia in December 1998. Around the same time, her husband used their 1996 marriage certificate to seek a green card for Ms. Rahman. Unaware of the removal proceedings, USCIS approved the petition. Ms. Rahman obtained lawful permanent resident status and came back to the U.S. in 2000. End quote. I could be wrong, but it seems she didn't appear for that hearing because she was in Bangladesh? Unclear. So now Ms. Rahman has an in absentia removal order and LPR status. And we're actually just getting started. She applied to naturalize 4 years later, but, quote, while her naturalization application remained pending, the government charged Ms. Rahman and her husband with federal offenses, end quote. The husband got 12 years in prison following a jury trial for financial crimes, while Ms. Rahman pled guilty to using a social security card that she obtained through fraud, essentially to obtain a driver's license way back when. She got 2 years probation. Removal proceedings initiated, again, anew. Naturalization denied. The removal proceedings lasted a decade, and I suppose the IJ eventually found that Miss Rahman committed a CIMT within 5 years of admission. Unsure what else the removal allegation would be, but in any event, Miss Rahman applied to readjust her status through her possibly incarcerated U.S. citizen husband with a waiver. 2 waivers, it appears, actually. See, the IJ believed Miss Rahman not only removable, but that she was inadmissible under INA Section 212A9B III for having been in the United States without authorization in the 90s for over a year and then departed, and additionally, under INA Section 212A6CI for fraudulently having failed to disclose her time in the United States in her green card application. Wild. And again, these inadmissibility provisions only apply because Miss Rahman has already been found removable and is now applying to readjust, which again brings in the inadmissibility grounds. And you know, though, there's a waiver for both inadmissibility provisions in conjunction with an application to adjust to LPR status. But both waivers are discretionary and require a showing of extreme hardship, absent a waiver to the U.S. citizen's spouse. Potential hardship to the 5 children is actually not considered for these waivers, unless you can make the argument that the hardship to those children will create hardship to the U.S. citizen's spouse. The immigration judge denied the waivers for a few reasons, and the BIA affirmed. The IJ does not appear to have liked Miss Rahman, if the multiple reasons for denying are any indication. And well, the Sixth Circuit said it couldn't even review any of it, despite Wilkinson, the Supreme Court's version, not the Third Circuit's. See, both waivers not only require a showing of extreme hardship to a qualifying relative, but are prefaced by the language that showing that the non-citizen must make is, quote, to the satisfaction of the Attorney General, end quote. I have always assumed that is a throwaway line, because what can that really mean? Isn't that just another way of saying that the non-citizen has a burden? Well, no. Actually, that phrase not only connotes a burden, but it has actual importance, jurisdictionally so. We are in Patel and INA Section 242A2B land. A fraud waiver is listed as something courts lack jurisdiction over to review, and well, the unlawful presence waiver similarly has a provision that limits circuit review. But of course, Wilkinson and Gulomjonov bring back jurisdiction for mixed questions of law and fact in certain circumstances. And the extreme hardship analysis seems to be one such possible phrase that would be a mixed question of law and fact. Because after all, Wilkinson held that, quote, extreme and exceptionally unusual hardship, end quote, describes a mixed question of law and fact. So we're taking out 2 words. Jurisdiction should be good then, assuming, I believe, that the facts are not in dispute below, and it's just application of those facts to the legal extreme hardship standard. Indeed, quote, at first blush, the case law would seem to support Miss Rahman's claim, end quote. But here's the thing, explained the Sixth Circuit. Law has many blushes. To the Sixth Circuit, as I mentioned, these waiver statutes are different from the cancellation of removal one that we just talked about and that was at issue in Wilkinson. These waivers are tethered to an extreme hardship and discretionary showing to the satisfaction of the Attorney General. To the court, that's just too discretionary. It could mean anything. How can they possibly review it? So they won't. Which, just to be clear, I guess means that an IJ or other immigration officer can deny a waiver for any reason, even racist or First Amendment violating reasons, and the Sixth Circuit would throw up its hands and say, we can't review that? I think so, but I'd be happy to be wrong. Words must be given meaning in statutes, states the court. And after all, quote, in expansive 1996 amendments to the immigration laws, Congress included the to the satisfaction language in the 2 waiver clauses, but not in the cancellation of removal statute, end quote. So it must mean something, says the court. Plus, the same language exists in the extraordinary circumstances exception to the 1-year deadline to filing for asylum, and many circuits have held that in that case, that issue is non-reviewable. Most recently in the 11th Circuit, APA v. U.S. Attorney General, Episode 215. 5 circuits, to be specific, have held that this phrase, to the satisfaction of the Attorney General, makes the issue unreviewable, at least in the extraordinary circumstances exception to the 1-year filing deadline for asylum. meaning that the Sixth Circuit enters a circuit split on the meaning of the "to the satisfaction of the Attorney General" phrase. The Sixth Circuit then went on to reject Ms. Rahman's argument that the IJ committed legal error in finding her not credible. Deeming her argument actually factual, it picked up on the very unfortunate and seemingly unnecessary language from the Supreme Court's Wilkinson decision to state that, quote, "The Supreme Court has held that credibility determinations qualify as unreviewable findings of fact," end quote. Oof. At least when tethered to the relief at INA Section 242A2B, everybody, not asylum, don't freak out. At least not yet. But it all means in a very complicated way that Miss Rahman lost her case. But am I wildly off base here? Did I miss something? Miss Rahman is not 212A9B barred, right? Because if I remember correctly, in matter of Duarte Gonzalez, episode 147, the BIA held that the 10-year bar for unlawful presence can run while the non-citizen is in the United States, provided they have left the United States and have a procedurally lawful entry, I think. And Miss Rahman has that. She got that green card, right, and came back? Now, the immigration judge denied all of this in 2019, so that was well before Duarte Gonzalez. And I don't know when the BIA affirmed, but I think it's worth noting. Doesn't really change much here because Ms. Rahman would still need the fraud waiver, which is pretty much the same standard and the same jurisdictional analysis to the Sixth Circuit. But again, worth noting, I don't think she's 212A9B barred. Remember Duarte Gonzalez. And that is Rahman v. Bondi. Next up is Dineshkumar Patel v. Bondi, published by the Sixth Circuit on March 11th, 2025. This case is about asylum and related relief and protection, and it also concerns India. 2 decades ago, her husband Dinesh got in serious trouble with local loan sharks who threatened to kill him and kidnap his children if he didn't pay. Dinesh never paid, the family never reported the threats, and the family fled to the United States, where they applied for asylum and immigration court proceedings on this basis. An immigration judge and the BIA denied. The Sixth Circuit here affirmed the agency. The two asserted particular social groups were, quote, victims of government-sanctioned extortion, end quote, and, quote, victims of threats, extortion, and kidnapping by loan sharks, end quote. The court probably doesn't believe those groups viable, but even putting that aside, explained the Sixth Circuit, the BIA wasn't wrong to believe that this wasn't a central reason or even a reason for the harm feared and the threats. Just a, quote, ordinary criminal desire for financial gain, end quote, reasoned the Sixth Circuit. Now, astute listeners will point to cases like Lopez-Quinteros v. Garland, episode 242 out of the First Circuit, whereby even though financial motives might be the initial reason for extortion against, say, a husband, if a private actor targets the spouse or children solely as a means to get to the husband, there very well may exist a sufficient nexus to a protected ground, provided you assert a viable and accurate particular social group, of course. Recent decisions like that out of the Ninth Circuit, too, I believe. No discussion of that by this Sixth Circuit panel. And to be fair, it might be because the particular social groups asserted could have connected the dots a bit better. And also, of course, because this family-based extortion mixed motive precedent is continuously developing. Anyway, though, the court didn't see a nexus to any particular social group. The court therefore turned to Convention Against Torture Protection and affirmed the denial of that, too. Among other issues, the Sixth Circuit doesn't believe that the family can show that the Indian government would consent or acquiesce to the torture feared because, well, the family never reported the fears. Quote, failure to inform authorities of threats by potential torturers typically dooms a CAT claim, as such evidence signals that the government did not turn a willfully blind eye to the applicant, end quote. Just like you're about to hear with the 10th Circuit case this week, a failure to report can be overcome with lots of specific country condition evidence that's really on point. But that was not submitted in this case. The Patel family therefore lost their case. And that is Dineshkumar Patel v. Bondi. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial College in Kansas City. Get ready for a transformative experience at the annual Immigration Court Trial Advocacy College, now hosted by the Pen and Sword, formerly the clinic at Sharma Crawford Attorneys at Law. That's friends of the pod and friends of the Kevin, Rekha and Michael Sharma Crawford, excellent immigration attorneys. The college convenes from April 24th to 26th and will focus on detentions, bonds, and release for 3 action-packed days of hands-on practical training and expert insights. This is not your average Talking Heads program. This is real cases, real witnesses, and real courtrooms designed to give you a real edge in your immigration practice. Put another way, this isn't just another training. It's an opportunity to transform your practice and fight for justice in a way that matters. Sharpen your skills, amplify your voice, defend immigrant rights like never before. Don't miss out, because space is limited. Check out all of the links to Rekha and Michael Sharma Crawford, their firm, and the Pen and Sword in the show notes. And if you want to get a bit of a discount for the Trial Advocacy College, click on the link in the show notes or use promo code IMREVIEW2025. That's IMMREVIEW2025. Keep up and join the good fight. Are you fighting like a maniac? Completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Welcome back. With Gulomjonov v. Bondi, published by the 7th Circuit on March 14th, 2025. This case is about asylum. Religious persecution, to be exact. And it's about exceptions to the 1-year filing deadline. Mr. Gulomjonov is from Uzbekistan, a predominantly Muslim country. And he grew up a Muslim. He came to the United States in 2016 at 18 years old and stayed here for a while in student status. He was authorized to remain in student status through January 2019. During that time, he testified in immigration court, he became interested in Catholicism based on conversations he had with a friend. It seems like later he had a bit of a run-in with the law, and he, quote, turned to Catholicism for solace and mercy, end quote. He began studying the Bible, and by March 2019 was regularly attending church. He told his boss all about it later that month, but he didn't want to tell his father and his Uzbeki Muslim friends out of fear. He was detained by ICE 11 months after his student visa expired. He told his father from detention about his conversion to Christianity in December 2019, and in February 2020, he applied for asylum in removal proceedings. So 13 months after his student status expired, but only like 3 months after his detention, and after he told his father. But that 13 months was way too much for the immigration judge who denied asylum on that basis. As we know, asylum applications must be filed within 1 year of a non-citizen's arrival in the United States. There is, however, a statutory changed circumstances exception, which provides that an asylum application, quote, may be considered, notwithstanding noncompliance with a 1-year filing deadline, if the non-citizen demonstrates to the satisfaction of the Attorney General the existence of changed circumstances which materially affect the applicant's eligibility for asylum, end quote. That's right, everyone. We're back to the satisfaction of the Attorney General. Will the Attorney General never be satisfied? It's giving Angelica Schuyler. The immigration judge, standing in the place of the unsatisfied Attorney General, was indeed satisfied that the conversion was a material change. But even then, the regulation says that an asylum application must be filed within a reasonable time of that change. Here, reasoned the IJ, the conversion was in or about April 2019, 10 months before the asylum application's filing in February 2020, and not a reasonable period of time. Mr. Gulomjonov argued that the reasonable time clock should begin in December 2019, when he told his father and thus put himself at risk of potential harm, I suppose. And that, of course, is only 3 months before he filed his asylum application. The IJ was not satisfied. The IJ then denied withholding of removal and cat protection on the merits, and the BIA affirmed. The BIA also rejected Mr. Gulomjonov's argument that additionally, the statutory extraordinary circumstances exception should apply, given his age, his holding student status for a whole lot of time, and his arrest and detention. The Seventh Circuit affirmed the agency. Before the court, Mr. Gulomjonov's primary argument was that the regulatory changed circumstances framework is improper. I suppose not due deference? That regulation is 8 C.F.R. section 1208.4A4II. And it is what requires an asylum application to be filed, quote, within a reasonable period of time given the changed circumstances, end quote. The statute doesn't say that. So the regulation is ultra-virus the statute? That's the argument, I guess. It's not, though, said the Seventh Circuit. But it's important to frame it that way because this is a question of law. As we'll see, if Mr. Gulomjonov only challenged the factual finding about whether his application was indeed filed timely, a circuit generally can't review that. But this is a purely legal dispute, and it's of course now governed by Loper Bright, as the agency's interpretation of INA Section 208A2's framework for timely asylum applications is no longer due deference. That said, however, quote, the court in Loper Bright made a point of emphasizing that when a particular statute delegates authority to an agency consistent with constitutional limits, courts must respect the delegation while ensuring that the agency acts within it, end quote. Oh mama, we're about to have our first pseudo-deference decision post-Loper Bright. E2 Seventh Circuit? E2? I read Loper Bright as saying that if you were going to have any deference, that deference had to be really explicit. What will you decide, Seventh Circuit? It starts out by explaining that the statute is simply silent about temporal limits on how long one has to file for asylum based on changed circumstances. But of course, the agency has implemented a regulation giving temporal limits, a reasonable time from the change. That's definitely ambiguity, or maybe not even ambiguity. But it doesn't matter, said the Seventh Circuit. Quote, the statutory delegation is broad enough to include the authority to set a time limit for filing applications, end quote. Here's why. First, quote, the language of the changed circumstances exception vests the Attorney General with wide discretion to determine whether changed circumstances warrant an exception to the general 1-year deadline. It provides that a late application may be considered if the non-citizen demonstrates, to the satisfaction of the Attorney General, the existence of changed circumstances which materially affect the applicant's eligibility for asylum, end quote. That, in turn, is a, quote, very broad delegation of discretionary authority. End quote. Reasoned the court. The, quote, agency's satisfaction is inherently discretionary, end quote. Indeed, the Attorney General demands satisfaction. And that broad authority, quote, implicitly includes the authority to promulgate a time requirement for those seeking to benefit from the exception, end quote. After all, continues the court, quote, doing something to the satisfaction of a decision maker is ordinarily understood to include doing so in accordance with the decision maker's procedural rules, including timing requirements, end quote. Also, explained the Seventh Circuit, it doesn't make sense to let a non-citizen wait many years after a material change occurs to then file their application, where asylum applications usually, absent a material change, must be filed within 1 year of coming to the United States. Hard to argue with that. So, The regulatory time limit on filing an asylum application after a material change is okay. But was the agency's decision to begin counting the relevant conversion in April rather than December 2019 also correct? Yes. Or that is to say, it was a factual question over which the circuit held it can't review the agency. Plus, the court does seem to think April is an appropriate time. Mr. Gulomjonov even told his boss at that time, if you recall. That the question is factual is a big problem, because one subsection of INA Section 208A blocks judicial review of the agency's decisions regarding the timeliness of asylum applications and the discretionary exceptions to the 1-year deadline. Kind of like a special jurisdiction stripping provision for certain asylum-related questions. With asylum out the door then, the court finally affirmed the agency's denial of withholding removal and cat protection. Mostly because Mr. Gulomjonov appears to have barely put up a fight on his petition for review on these issues. Seems like this whole dispute was mostly about the 1-year asylum deadline stuff. In any event, the Sixth Circuit sees little more than harassment and discrimination of Christians in Uzbekistan, not persecution, at least based on this record. Which all meant that Mr. Gulomjonov lost his case. And that is Gulomjonov v. Bondi. Concluding then as we must with Singh v. Bondi, published by the 10th Circuit on March 11th, 2025. This case is about the unwilling or unable to protect standard for asylum and withholding of removal. Mr. Singh is a Sikh from the Punjab region of India, who is a member of the Man Party, quote, which advocates for Sikh separatism from India, end quote. Notably, though, and the first time I've ever seen this in one of these cases, quote, have held that demanding Sikh independence is not a crime, end quote. And yet, Man Party members are targeted in India, both by the governing BJP party and other Hindu-centered parties, and by the Patel party, quote, the more moderate mainstream Sikh party, end quote. Mr. Singh applied for asylum in an immigration court in Utah. His claim begins with the 2000 incident where Badal members tried to recruit him. He was attacked when he said no and went to police, who refused to take a report and actually threatened to fabricate a case against Mr. Singh. 10 days later, they arrested him for allegedly possessing a revolver and ammunition. He was stripped and held for 3 days at a police station. That police officer inspector was then arrested for corruption weeks later. Mr. Singh was ultimately acquitted after fighting the charges in court, but apparently never mentioned the police abuse. He left his home and didn't return for years, having learned that police were looking for him. When he returned in 2015 and resumed his Man Party activities, he fled again after police came looking for him. In 2017, he was assaulted by Badal and BJP members who beat him with their fists and feet. He was able to flee but was attacked 6 months later with hockey sticks and knocked unconscious. Police refused to take his report and kicked him out of the police station. I'm not gonna lie, it is striking to me that, like many of these cases, he was beat with hockey sticks, and it was his father who took him to the police station before police refused to take his case. Mr. Singh came to the United States. An immigration judge and the BIA denied, finding among other things that the harm wasn't bad enough to be past persecution. Plus, it looked like the government could have helped him. After all, reasoned the BIA, he was cleared of that false criminal accusation in the early 2000s. To the 10th Circuit, it became all about that latter thing. Did Mr. Singh show that in the past or future, the Indian government was unable or unwilling to protect him? An asylum element that, for better or for worse, often comes down to what police did or did not do and what the non-citizen did or did not report. Actually, footnote 13 in this decision is quite an interesting explanation as to how and why that has all come about over the years. Here, the 10th Circuit affirmed the agency. Not before noting, though, in another footnote that Mr. Singh could have but did not allege that actually he suffered past persecution by the government itself. Because remember, it was police who did that stuff to him at the station in 2000. But because here only private actor persecution was asserted, members of these political parties, I imagine, Mr. Singh had to show that the Indian government was unable or unwilling to protect him. And he did not do so, said the 10th Circuit. But isn't BJP kind of the government? I'll stop. The 10th Circuit starts out and notes that there's a circuit split on whether a past persecution finding is a question of fact or a mixed question of law and fact. But in the 10th Circuit, it's a straight factual question, even if the underlying facts are not in dispute. Interesting. I'll spare you the gong. Anyway, remember, quote, an applicant need not prove both inability and unwillingness. It suffices to show either that the government was unable to control persecutors or that the government was unwilling to control persecutors, end quote. Emphasis by the court. And good to remember because I love this, quote, an able but unwilling government, or a willing but unable government, no more protects its people from private persecution than an unable and unwilling government, end quote. The oars matter, as Supreme Court precedent has shown us over the years. Still, the asylum seeker has the burden, and it's often not easy to meet. It can be shown by country condition evidence or by showing how police did not respond, explains the 10th Circuit. To the court, failing to report harm to police, though, often tanks these claims, because, quote, without such notice, there is no way to know how the police would have reacted or whether the government would have helped, end quote. But again, still can be saved with country condition evidence. Mr. Singh argued that the BIA only considered the Indian government's willingness, but not ability to protect. A winning argument, said the 10th Circuit. If that's what the BIA had done. But it's not. Even if the BIA didn't use separate legal headings in its decision, explained the court, the BIA considered evidence pertinent to both willingness and ability, and it deemed it lacking. Good enough here, at least where again the evidence presented and considered went to both willingness and ability. I guess. Not much more analysis given by the court, so not much more for me to review. As to whether the Indian government was able and willing to protect Mr. Singh, well, the evidence didn't compel reversal, explained the 10th Circuit. He was cleared of those false charges, remember? So the government can do some stuff, reasoned the BIA and the court. And they even arrested the officers in charge of that police incident. In any event, Mr. Singh never reported that he was abused by police to, I suppose, the police. Regarding his 2 attacks 16 years later, Mr. Singh never reported those either, and the BIA and 10th Circuit did not see sufficient evidence to show that doing so would have been, quote, futile or dangerous, end quote. Faced with this, it was country conditions or bust for Mr. Singh, but the 10th Circuit didn't see an independent, unable, or unwilling to protect showing from them. First off, the BIA did consider the evidence, explains the court. And second, while the State Department reports for India definitely mentioned corruption and even horrible actions by police, the court saw 2 problems that are often present with Department of State reports. Quote, first, the bulk of the evidence reflects generalized corruption, not sectarian corruption in Punjab against Maan advocates. Second, the country conditions evidence is not one-sided. It contains evidence that supports India's ability and willingness to control corruption and political persecution, end quote. So of course, always flood the record with germane, reputable country condition reports in addition to the Department of State. It all meant in this case, though, that Mr. Singh did not succeed. And that is Singh v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to, from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.